Good afternoon, everyone. Thank you so much for your patience. We were experiencing some technical difficulties, but we're all ready to go. Thank you for taking the time to participate in today's live webinar. Today, we have enlisted the help of a special guest speaker to help us understand the recent changes to the Long-Term Care Resident Bill of Rights as outlined in the new Fixing Long-Term Care Act 2021. Before I introduce our guest, I wanted to review some housekeeping announcements. You'll notice that all participants are in listen-only mode. We've muted your audio in an effort to eliminate background noise and distractions for our speaker. For ease of access, closed captioning has been enabled for this webinar. This session is being recorded for educational purposes and will be available on our website. We have protected time for an interactive question and answer period at the end of today's webinar, at which time we'll invite you to type your questions into the question box. Without further delay, I'd like to give a warm welcome to our guest, Jane Meadus. Jane is a staff lawyer and the institutional advocate at the Advocacy Centre for the Elderly. She represents clients in long-term care homes, hospitals, psychiatric facilities, and care homes, retirement homes, with respects to related legal issues. Jane is a regular speaker at educational seminars and before various groups. Jane is a distinguished fellow of the Canadian Centre for Elder Law Studies. Without further ado, welcome, Jane. I'll hand it over to you.
Care Homes Act, the Fixing Long-Term Care Act, and the regulations and the residents' rights under them. And just to say that this is not legal advice, this is legal information. Legal advice is fact specific, and I won't be answering any specific questions related to people, but general questions at the end, hopefully. Next slide. So this is an overview of long-term care homes, which you probably know. There's about 78,000 people in long-term care, huge waiting lists. Resident demographics, 83-year-old is the average, 69% are female, and 64% have some sort of dementia or Alzheimer's disease. 90% have 3 or more active conditions. So this, it just gives you an overview of what is in the, what kind of people reside in long-term care. And just so you know that, in long-term care, there are for-profit, not-for-profit, municipal homes, charitable homes. So there's a variety of different kinds of homes, but you shouldn't know what kind of home it is. Every home should theoretically be working in the same way and providing similar services. People find that maybe that's not always the case, but that is theoretically how it is supposed to go. Next slide. So the Fixing Long-Term Care Act 2021, it was passed, it was part of a larger piece of legislation. This was the main part of it. And there were changes to some other legislation, such as the Retirement Homes Act. There were debates in November, which was a very small amount of debate in the House, and was sent to committee. There was only a few days to prepare for committees. It went to the Standing Committee on Legislative Assembly. There were written and oral submissions. You can read if you want to know what was discussed in either the House or at the committees, you can read the transcripts online. The oral submissions were from the 23rd to the 25th, but the 23rd was all Ministry of Long-Term Care. And then there were 12 other oral submissions. And this really isn't a lot of submissions. There wasn't a lot of time. There wasn't a lot of changes made from these submissions. And it received royal assent on December 9th. Regulations were put out for public consultation on January 18th for 30 days. And then the act and the regulations were enacted on April 11th. So we've just a month into the legislation now. Next slide. So we have, when you're looking at law, There's two parts to it. There's the Act, which would be the Fixing Long-Term Care Act, and it's sort of the framework of what is in the law. And then you have the regulations, which is sort of the meat and potatoes of it. So, you know, you have to look at both pieces to sort of understand how the whole of long-term care works together. The Fixing Long-Term Care Act is extremely long, both the Act and the regulations. These are not short, simple pieces of legislation. They are very long and detailed. However, the residents' rights specifically are only in the Act, but there are parts of the regulations that do inform the residents' rights, and I'll be referring to some of those. Next slide. So there's certain sections that are in the Act that I just wanted to point out that have not been passed. One is the confinement section, and I think there's some people asking whether or not the slides will be available after, and the answer is yes. You will be able to get copies of the slides after for sure, and I assume that probably there will be some other kind of availability of the video later on. The confinement sections, there were confinement sections in the last legislation, the Long-Term Care Homes Act as well, and they too have never been enacted. So that means that there is no rules with respect to confinement. That means preventing a person from leaving either a floor or a facility. And this is very problematic because you cannot confine a person without due process. And unfortunately, the government has not passed the due process section. So this is really problematic for both residents and homes because you get overly broad restrictions that homes try to impart where people are being refused to be allowed out of the homes. Homes will have those kind of policies, but it also means that when they do want to restrict someone, there is no ability to have due process. That means to appeal, to know why you're being restricted. And, you know, it's certainly understandable in long-term care that people will be restricted. There are people who have dementia. If they were let out of the home or into other parts of the home, they might come to harm. But the problem is that they're not being done legally. So we have been pushing for many, many years, probably my entire time, over 25 years at ACE, trying to get sections passed so that if there is confinement, if there is that trying to stop people from going from one place in the home to another or to leave the home, they will only be done in accordance with the law. But so far that hasn't happened. Next part. There's also a section on a review by the minister, and this would be a review as to whether or not a license should be issued, license transferred or beds transferred, on whether there should be an undertaking. And it would be the ability of a person, could be a resident or someone else, to question that. Again, this is a section that's there but has not been enacted, and there's no date set for enactment. Next. So there's some regulatory amendments as well, and the specific ones that have not yet been put in place is section 77 of the regulations, which deal with menu planning, and there are some changes to the menu planning, and that will be effective on July 11th, 2022, and that will includes changes to the choices, no longer referring to the Canada Food Guide, etc. And also admission sections around pandemic admission from hospital, and that will be effective October the 11th of 2022. Next slide. People should also be aware that there's complementary legislation. So those are other pieces of legislation that you also have to, you know, take into consideration when you're living in a long-term care home, things like the Healthcare Consent Act, Substitute Decisions Act, Personal Health Information Protection Act, Fire Code, all those other things also apply to long-term care homes. And there's many, many, many pieces of legislation, and this is just a small portion of them that could also apply in long-term care. Next. So now we're going to go to the Resident Bill of Rights. Next. So the first thing that you have to know is that there is a fundamental principle in the legislation, and this hasn't changed. And that means that this principle is that basically that this is the home of the resident and is a place where they're entitled to live in dignity and security, safety, comfort, and have their physical, psychological, social, spiritual, and cultural needs adequately met. And that means that everything in the Act really has to be interpreted through that principle. Next. There's also a very lengthy preamble, and this is one of the changes from the Long-Term Care Homes Act to the Fixing Long-Term Care Act. And what the preamble is, it sets out what the government's purposes and the goals of the legislation, and it has increased quite dramatically under this legislation. And I'm not going to go through the entire thing, but I'm going to sort of hit some highlights. Next. So it's certainly looking at, you know, the diversity of the residents in their communities, French language, Indigenous people, people with diverse, complex physical and mental health needs. So the Act is really recognizing that these are homes for those people and that we have to ensure that their needs are being met. Next slide. They want to have quality in their services and accommodation, and really make it a home-like environment. And that's the goal of what's going on here. And to ensure that others, including families, members, and caregivers, are also included where appropriate. Next. Again, recognizing the importance of caregivers is highlighted, the workforce, that it's to be excellent care, and that they want Ontarians to have trust and confidence in the system, and that it is governed and operated in a way that reflects the interests of the public, and that it delivers high quality care and services to all residents. Next. There's also sections around accountability and transparency so that people know what's going on and that the homes and the government are accountable to the public and the residents when it comes to long-term care. Next. And it also talks about the availability of information to the public, and that has to do with long-term care home reports, for example. You know, accessing home beds based on needs. And what we also, a new one here, which came out of the Long-Term Care Commission from the COVID-19 Commission, is that they are to promote the delivery of long-term care home services by not-for-profit and what they call mission-driven organizations. And this is a new concept from the COVID-19 Commission. It's not known how this will be implemented, but certainly in the COVID-19 report, it talks about homes that perhaps are for-profit, owning the building, but the services being provided by someone else who is not for profit, so that they're not getting profit out of the care services, but just out of the building, and that they're able to get the private sector to build the buildings, and but not necessarily always provide the services unless they have what they call a mission-driven organization, which is not really well defined. Okay, next. So the Residents' Bill of Rights is interpreted as a contract. That's the Act, the regulations, any kind of policies, agreements. But you have to know that just because something isn't a right that appears in the legislation doesn't mean that the resident doesn't have the right. So sometimes people think that the only rights residents have are what is set out in the legislation and then the residents' rights. But in fact, you don't lose rights, or you shouldn't lose rights just because you're being admitted to a long-term care home. You continue to have all the rights you should have as a citizen and as a member of the community. Those are not removed just because you live in a long-term care home. Next. There's a number of changes to the Residents' Bill of Rights, which we're going to be talking about today. But specifically, the legislation has gone from 27 rights to 29. So we have 2 that have been added, and those have to do with caregiver support, which is number 20, and the palliative care philosophy, which is number 25. The amendments to wording, some minor change in wording, and I have highlighted those in the sections in the slides to follow. We've also had a regrouping of the rights. So the rights are now grouped under specific headings. So it makes it a little flow a little better so that all the rights, particularly to a certain kind of heading, will be together. And it has also been made gender neutral. So the removal of the word his or her and replaced with the neutral there. Next slide. So there are 5 new headings, and there was no headings under the old Bill of Rights. So there's 5 headings that have been included. It's the right to be treated with respect, the right to freedom from abuse and neglect, the right to an optimal quality of life, the right to quality care and self-determination, the right to be informed, participate, and make a complaint. So all the rights have been slotted under one of these new headings. Go ahead. So we're going to talk first about the right to be treated with respect. Go ahead. So the first right is the right to be treated with courtesy and respect, and in a way fully recognizing the resident's inherent dignity and worth and individuality, regardless of their race, ancestry, place of origin, color, ethnic origin, citizenship, creed, sex, sexual orientation, gender identity, gender expression, age, marital status, family status, or disability. So the words in highlighted are the changes. And one thing that it did was that it really changed to reflect the wording under the Ontario Human Rights Code, and that was a recommendation that has come from a number of different sources. But the Ontario Human Rights Code always applied to long-term care. So really that right always included all of those things. And you should know that, even if it's not necessary under this right, that residents in long-term care homes, the services and what goes on in long-term care is still governed by the Ontario Human Rights Code. So there isn't really any change there. They've just taken the wording from the Ontario Human Rights Code and included it in the right to make it very clear that all those rights are there. But they were there anyway because the Ontario Human Rights Code has always applied. Next slide. Residence right number 2, there's not been any change here. So it's the right to have the lifestyle and choice respected. This means that it's the resident home. They don't have to change to live there. And that staff may not impose their own moral opinions on residents, shouldn't be commenting on lifestyles of people, which is something that we hear fairly frequently at our office, where people are saying that staff members are making comments that are really inappropriate. And so this right is the one that covers that. Next slide. Number 3, every resident has the right to participate in their decision-making. That does not mean that residents are necessarily going to be their own decision makers. Again, that has to do with capacity, but it means that they have to be included. So even an incapable resident should be included in meetings. And, they can refuse. There are certainly times when people cannot attend because they are ill or for other reasons, perhaps they're, totally unable to that they're very disruptive because of behavioral issues. But generally, residents should always be invited to care meetings and the like, even if they're incapable. Next slide. So the next heading that we have is the right to freedom from abuse and neglect. Next slide, thank you. So I've put both on this slide here. Because they had identical changes. So it's now the right to freedom from abuse and freedom from neglect by the licensee and staff. And previously it was protected from. Not clear exactly what the purpose of that change was. We'll see if there's any change in the way it's being interpreted. I don't think that they will be. But they are tied to the abuse sections in the Act and regulations. So I'm just going to very quickly show you what those sections are. And again, you can get the slides and have a really good look at what those sections are at a later date on your own. Next slide. So there's legislative components in the Act with respect to the abuse prevention in long-term care homes. It's the definitions of abuse are in the regulations. It's in the Residence Bill of Rights. There's a duty to protect by the licensee. There are reporting requirements to the director by anyone except for the resident or legal counsel. Licensee obligations with respect to reporting, investigations, different actions that have to be taken. There's policies around abuse, staff orientation and mandatory training, and specific screening measures. Next slide. So the Act sets out various definitions, and the regulations are the definitions. So this is for the physical abuse. Next slide. Sexual abuse is a specific category. Next slide. Verbal abuse. So that could be any kind of verbal threatening or intimidating that is abuse under the Act. Next slide. Financial abuse, and I always like to point out that this includes property. So for example, we've had cases where people have had their wheelchairs taken away from them. Homes do not have authority to confiscate items. They cannot do that. And we've had homes found to be non-compliant because of that, that they were found to have had financially abused because they had taken the person's property. Next slide. Emotional abuse, so any kinds of insults, threatening, intimidating. These are all types of emotional abuse. Next slide. And then there's a definition of neglect, which is the failure to provide a resident with the treatment, care, services, or assistance required for health, safety, or well-being, including inaction or a pattern of inaction that jeopardizes the safety or health, safety, or well-being of one or more residents. And what you should know is that the definitions for neglect and abuse have not changed under the new legislation. Next slide. There's to be no retaliation against residents who may complain or to anyone. We know that this happens, and if it does happen, that should be reported immediately to the ministry if they find that they are being discriminated against or threatened if they make complaints. And we certainly hear that from both residents and families where, for example, people are threatened with discharge, told, well, if you don't like it, go somewhere else. And that should absolutely not be tolerated and should be reported immediately. Next slide. There are obligations on the licensee to protect residents from abuse by anyone and neglect by licensee or staff. So the difference is that, so if the home becomes aware of any kind of abuse by anyone, they must report it, protect them from that, but it's only neglect by licensee or staff. There's reporting requirements, investigation requirements that are set out here, and they do have to report to the director. Next slide. So the duty to report, there's very specific duty to report by anyone except by the resident or their legal counsel. So improper and incompetent treatment or care of a resident that's resulted in harm or risk, abuse, neglect, unlawful conduct, misappropriation of residents' money, and misappropriation of funding provided to a licensee. All of those are reportable, and that's by anyone. So anyone must report except for a resident or legal counsel. Next slide. However, if certain people fail to report, which is the licensee, any member of management, staff, or anyone working in a professional services such as health, social worker, social service worker. So that would include, for example, a health worker in a hospital that becomes aware of some kind of abuse. They actually are mandatory reporting, and they actually can be, that is an actual offense if they do not report. So it's very important for all of the staff and the management and licensees, as well as other health practitioners or social service workers and social workers, to know that they actually must by law report, or they can be found guilty of an offense. Next slide. Homes have to have a policy of zero tolerance, which is set out here. And that is similar to what was in the last piece of legislation. Next slide. There's also mandatory police reporting of certain types of abuse. And that's where they meet the definition of abuse or neglect and may constitute a criminal offense. So the home doesn't have to determine whether it's a criminal offense. It's just whether it may be a criminal offense. In those cases, they must report it to the police. However, homes can report other things as well. So there's other things that may not meet that level of what abuse is, but still may be a criminal offense. So physical abuse, for example, from resident to resident is only when there is a harm that occurs. However, harm can occur, and it could be may not occur, but it still could be an assault under the criminal code. So we definitely can still have that reported, and homes need to understand. So if someone is going around and purposely knocking over residents, just because they haven't been harmed yet, doesn't mean that home can't report and maybe should report that, but it is not mandatory under the legislation. The next heading is the right to an optimal quality of life. And that includes the right to communicate in confidence, receive visitors of their choice, and consult in private with any person without interference. Now, this is one that I wanted to spend a little time, because although the right hasn't changed, the regulations have. And so homes are now required to have visitor policies, and this is a new thing. They've never had to have them before. Ostensibly to ensure that visitors are allowed in because of the problems that occurred during COVID. However, it can conflict with this section if they interfere with visitors by limiting where and when they can visit, barring them, and serving trespass notices, etc. Next slide. So the regulation sets out the visitor policy, and it says each home has to have a visitor policy that includes process for access during outbreaks and one for non-outbreaks, process for designating and documenting caregivers. It has to comply with all applicable laws, directive orders, etc. It requires visitor logs, and the policy must be provided to the Residence Council and Family Council, if any, but does not require any input from them. Next slide. It defines essential visitors as a caregiver, a support worker who visits a home to provide support to the critical operations of the home or to provide essential services to residents, a person visiting a very ill resident for compassionate reasons, including but not limited to hospice services or end of life, and a government inspector. Next slide. So the issues that we see, so it's the first time we've seen a legislative requirement, and we're already seeing policies where homes are placing limitations on visitors, which we believe are in contravention of the resident rights, which include that the home cannot, because the resident right says that the home cannot interfere with visitors. So our opinion at ACE is that if the policy interferes with the visitor, so for example, putting hours of visitation, for example, that is an interference that the home themselves can't do. So the ministry is allowing homes to create policy, but instructing them to seek their own legal counsel when creating them, distancing themselves from some of these policies, which may not be legal. And our opinion is that while some authorities, such as public health, for example, may have authority to restrict visitors in certain situations under legislation, we don't believe that the homes can restrict it. So if a home is saying, for example, having visitor hours or making restrictions outside something that may be under the COVID requirements, that's going to be a problem. And we've already had complaints about this. And we do see this as going to be moving forward. I think this is going to be an area where we see a lot of complaints. Next slide. We also continue to see the issuing of trespass notices against visitors. This is often against caregivers who complain about care within the home. I think that these trespass notices and their use are retaliation and therefore contravene whistleblowing protection. However, our opinion is that the Trespass to Property Act cannot be used if the person is a legal visitor. And as the resident has a right to the visitor conferred by law under the Resident Bill of Rights, The Trespass to Property Act cannot be used to prevent visitors from coming in. So if the person's an actual visitor, they cannot be used. And so if there's someone who has a visitor who receives a trespass notice, they should seek, the visitor themselves should seek legal advice from the private bar. We do not represent visitors under Trespass to Property Act legislation. If a resident has an issue with that, they can contact us and we will speak to them about that if they have a visitor that is being trespassed, but we do not represent the visitors themselves. Next slide. So right number 7 remains the same. You're allowed to have friendships and relationships in the home and participate. Next slide. Number 8, you have the right to share a room if you want to with someone else. One of the problems that we've identified with the new builds is that many of these homes do not have shared accommodation at all. So all rooms are single rooms, no matter what you're paying in that room. And this has really been problematic for couples because they are not able to stay in the same room together. And this is something that we have brought up to the ministry. New slide. Every resident has a right to meet privately with their spouse or another person in a room that assures privacy. So residents are entitled to intimacy. So if you share a room, there should be a place where you can go to be intimate with someone. You're also entitled to meet with anyone without being overheard by roommates, staff, etc. So this is something that would allow that and require the home to provide that. Next slide. You're allowed to pursue your social, cultural, religious, spiritual, and other interests to develop them. And the licensee is to assist you with that. Next slide. Still, the resident has a right to live in a safe and clean environment. It's pretty sad that we have to include that as a right, but that is one of the rights that's included. Next slide. Every resident has a right to be given access to an outdoor area that's protected. And we did have some questions before this on this. So this is to ensure that residents who might wander have a safe place to enjoy the outdoors. This does not replace the ability of residents to leave a home. So residents can't be told, well, that's the only place that you can go, unless, for example, it's, under COVID, restrictions under an order. So the residents definitely should have access to outdoors unless it's impossible. So there are landlocked homes that just don't have the space outside, where the footprint of the home is the entire area, and so that they're not able to have outdoor areas. But if there is some area, the home must provide that. Next slide. Every resident has a right to keep and display personal possessions and furnishings in their room. So this is, it's certainly limited by space, fire code, safety issues. Residents can ask for locked drawers to keep personal items in. So many of my clients do ask for those so that they can lock things in. Because there are issues with people going in and out of rooms. Some items may be required to be locked in separate areas, such as tobacco, cannabis, and alcohol. And however, the home must allow access to these items when the residents request. There isn't anything specific around what you can and cannot have in your room. Again, it depends on space and other things. And again, there may be some safety issues around certain items that have to be kept separate just for safety reasons. Next slide. Every resident has the right to manage their own financial affairs unless they lack the capacity to do so. So just because you've given a power of attorney for property to someone, if you're competent, you retain your ability to manage your affairs unless you become incapable. Some homes have documents which purport to appoint someone when you're admitted to manage or be responsible for your financial affairs, and those appointments are not legal. Only a continuing power of attorney for property can appoint someone who can act for you when you're capable and incapable. Other than there are other, that's the only way you can appoint someone. If a resident becomes, go back one. If a resident becomes incapable during the time in the home and they haven't given a power of attorney for property, there are legal processes to have a statutory guardian appointed or have trustees appointed depending on the situation. Next slide. Every resident has the right to exercise all the rights of a citizen, and you don't lose those rights just because you move into a long-term care home. Next slide. The next topic is right to quality care and self-determination. So here there's been a change. Every resident has the right to proper accommodation, nutrition, care, and services consistent with their needs. And the previous wording was the right to be properly sheltered, fed, clothed, groomed, and cared for in a manner consistent with his or her needs. So again, it's been made gender neutral, and a little bit of a change in the wording that they have made. Hopefully it won't, it won't likely make much of a difference, but there has been a change in wording. Next slide. Every resident has a right to be told who's responsible for their care. And staff do not have the right of privacy. So they can't say, well, my name is private. No, they have to provide that. Next slide. Every resident has a right to be afforded privacy and treatment in caring for their personal needs. So that means the use of privacy curtains, doors being closed, and not being given care or treatment in public spaces such as hallways. Next, right. So right number 19 has to do with care plans and consent and health information. So it's got 4 parts to it. So the first 2 are here. The resident has the right to participate fully in the development, implementation, review, and revision of their plan of care. And of course, that's whether they're capable or not capable. And as long as they're capable, they get to refuse to consent to any treatment, care, or services for which their consent is required. And if they're not capable, that would be by their substitute decision maker. And you also have the right to refuse consent. So you are entitled to refuse to consent to a treatment. Next slide. Every resident has the right to participate in the decision regarding their care, including any decision concerning their admission, discharge, or transfer to or from a long-term care home, and to obtain an independent opinion, and to have their health information protected in accordance with the Personal Health Information Protection Act. This is the list of things that you get to consent to is not exclusive in these sections. There's other things that would require consent, but this is the list that's in the Bill of Rights. And most often where we see a lot of issues are around the room transfers, where it's in a facility where residents or substitute decision makers are not consulted. And this can be quite a problem where people are told that they're going to be moved without consent. The home does have the authority to consent, but they must discuss it with you and allow you to participate in that decision. But at the end of the day, they can move people. Next slide. Every resident has a right to ongoing and safe support from their caregivers to support their mental health, social, and emotional well-being and their quality of life, and to assistance in contacting a caregiver or other person to support their needs. This is new, and this is a direct result of the barring of caregivers during the pandemic. So you now have a right to have a caregiver to support you in the home. I still believe that this right can be overridden by orders under the Health Protection and Promotion Act. There certainly could be times when we could see it again, because that act would still supersede these in cases of extreme emergency. But I think that what they've done is they're really trying to ensure that, except in absolutely in a case where it would be absolutely impossible for someone to come in and visit safely, that they must promote that. Next slide. So I realize this is out of order, but I'm going to go back to the informed consent. So informed consent is set out in the Healthcare Consent Act and applies to all treatment, personal assistance services in a long-term care home, except in emergencies situation. You can't be treated without the health practitioner getting informed consent first. It has to be obtained from the resident if they're mentally capable. And if they're not mentally capable, it's from their substitute decision maker. Again, just because you've given someone a power of attorney for personal care does not give them the authority to make any decision about you unless you've been determined to be incapable. And that determination is done by the health practitioner who is proposing the treatment. Everyone who is incapable does have a substitute. If you have no family that meets the, you've never done a power of attorney, you have no family, etc., it's the public guardian and trustee as decision maker of last resort. The Healthcare Consent Act sets out what informed consent means. And if a resident is found incapable of making a decision for treatment or personal assistance services, they do have the right to apply to the Consent Capacity Board to challenge that finding. Next slide. Residents do have access to records under PHIPA. The residents and their substitute decision makers, where applicable, have a right of access to the health records. And if information is required to make a decision, so say you want information out of your record to make a treatment decision, that information should be provided right away. If not, if it's just when you want a copy of your records, though, it has to be made the request has to be made in writing, and the home has 30 days to respond, and they can charge for copies and that sort of thing. For example, it's $30 for the first 20 pages and 25 cents a page after that the home may charge for those records. Next slide. Every resident has the right to have a family or friend attend a meeting, and that would include an advocate or legal counsel. Next. Every resident has a right to designate someone to be told if they're being transferred to hospital. This is not the designation of a substitute decision maker. What it is the ability to have someone advise so that the person can have someone know that they have gone to the hospital and potentially come and support them there. Next slide. The resident has a right to receive care and assistance towards independence based on restorative care philosophy. And there's always a lot of questions about this with respect to how much physiotherapy, so for example, that you're entitled to have. And this is sort of an ongoing debate and ongoing difficulty that many residents who want more things like physiotherapy and can't access them in the community because they live in a long-term care home can have. And I suspect that at some point we may have a human rights challenge on this because of the limitations that sometimes occur in long-term care. Next slide. Right number 24 is the right not to be restrained except in the limited circumstances provided for under this act. At some point, if they ever put the confinement section, it would say restrained or confined. But again, we don't have any confinement sections in this act. So in law, there is no ability for a home to confine anyone, although we know they do it because of people who might come into harm, but they are only allowed to do that under the common law, which means in an emergency. So theoretically, they're supposed to decide every time a person tries to leave a floor or the building, whether or not they should be refused to leave. Doesn't happen. We know that people are certainly, allowed, are sort of set out as being not allowed out, but that's what the law says. The next one is right to be informed, participate, and make a complaint. Next slide. So every resident has the right to be provided with care and services based on a palliative care philosophy. And this is a new section. Palliative does not mean end of life care. There is a palliative care information sheet that you can get that you can see how it is defined, but it is a philosophy. It's really not clear to me personally exactly what the palliative care sections mean. I don't like the wording. I wish they'd use something else. I think it means something to physicians. I'm not sure that it means much to the general public, the difference between palliative care and a palliative care philosophy. And I can say that I believe on June the 14th, Dr. Fred Mather is going to be talking about this entirely in a separate webinar. So hopefully you'll be able to attend that, because I really think that this issue of the palliative care philosophy is very difficult for us to understand, because it really does sound like that everyone is going in there to die, and that apparently is not what this palliative care philosophy means. It really means to support people. And Dr. Mather will be discussing that further at another webinar. Next slide. Every resident who is dying or who is very ill has the right to have family and friends present 24 hours a day. There's no definition of what very ill is. There's nothing that limits the number. So again, it's often up to the home to determine exactly how this is going to be interpreted. Next slide. Every resident has a right to be informed in writing of laws or policies. There are certain policies that the home must provide. They have to provide the policy on zero tolerance of abuse and neglect of residents, and the written procedure to make complaints to the director. Residents and their substitutes have to be notified of the policy to minimize restraints and be told how to get a copy of that policy. However, despite this, you have a right of access to any policy that affects you. So the home should not be refusing to provide you on request of any policy that they have if it's affecting you. Next slide. Every resident has the right to participate in residence councils, and I'm sure OARC would do a much better job on this, but it's certainly not just capable residents. The home should be assisting residents in attending, and substitute decision makers, family members, essential caregivers cannot attend on a resident's behalf. And finally, number 29. And that has to do with every resident has a right to raise concerns with respect to policies and services, etc., with anyone. And that includes residence councils, family councils, licensees, staff members, government, and any other person inside or outside the long-term care home. And we certainly see homes trying to restrict that, residents getting in trouble for contacting people about complaints, but certainly the resident has every right to raise concerns in any way they want. Next slide. We've been asked about some of the resources. So the Every Resident book, which some people call the Clio book, is the one with the pictures in it. That's written by my office, as well as Clio, which is publishing arm of Legal Aid Ontario clinics. It does have to be rewritten and republished. We are working on putting a insert in to the old versions, because most of the rights haven't changed. They've just been reordered. Once the new version is written, hard copies will be available again for free from Clio, and will be available electronically on their website. There will be a French version coming later. Other versions in different languages for FASICs. Those are created by other organizations. We would certainly work with them. We will hopefully be working to get the aphasic version done. I understand that the Resident Bill of Rights itself has been translated through OARC into about 20 different languages and is available on their website. Doesn't have the explanations that's in the Resident Bill of Rights booklet, Every Resident, but it's certainly there. And so do we have a couple of minutes for questions? I believe I'm done.
Hi, Jane. Thank you again. And thank you everyone for your patience and for staying until the very end here. We do have some questions that have come in. So for those who need to jump off because it is 2:59, please do so. Thank you for being here today. And a reminder that the recording and the slide deck will be made available to you after this. So if you have to go, completely understandable. We'll take about 5 minutes just to go through some of the questions that have come in the chat. Jane, so there's one here from someone asking about how does the confinement legislation or lack thereof apply in the cases of COVID outbreaks? So confinement to rooms and floors, cohorting, in other words.
Right. So that's been a real contentious issue. So the directives that the Chief Medical Officer of Health, those certainly are in place and indicate that they have indicated that there should be restrictions. Our legal opinion at ACE is that while the Chief Medical Officer of Health does have authority to put in confinement sections, they have not done so, and they have not done so throughout the pandemic. They can set out orders, and orders do allow for confinement, and that would be in the community. If you there's all, in all different public health areas, there's different kinds of confinement sections. However, the Chief Medical Officer of Health has not ever passed an order with respect to long-term care. So we actually think that the confinement is in fact not legal. That doesn't mean we don't think you should be following the directions, but it's not really being done legally. And we have brought this up on numerous occasions with the ministry, and they have declined to, and the Chief Medical Officer of Health has declined to actually put in proper orders. I don't know why you'd have to ask them.
Okay, thank you. And then there's another question, a couple of questions that seem to be related to POA and personal care versus substitute decision maker. If you could comment on if there is a capable resident who perhaps would prefer to defer to a family member, even though they could make the decision on their own, how would something like that work?
So just so that you know, so that there's a hierarchy in the Healthcare Consent Act that sets out who everyone is. So an attorney for personal care that you've named in a power of attorney is one type of a substitute decision maker. It's one of the higher ones. And if you don't have one, then there's a list of family members. However, if you are capable, the law says that they must get the consent from you. You cannot defer. Capable people are the only people who can consent. That doesn't mean that you couldn't say, do whatever your family member tells you to do, but you are the person that must consent. You cannot defer.
Okay, thank you. And just doing another survey here. So some of the questions that are coming in will be home specific, so specific to policies that are in the individual homes. So just in the interest of answering one that would capture the most number of residents or most number of participants, Jane, you did mention about the different versions of the Resident Bill of Rights that are coming out. So the booklet, the Clio booklet that everyone seems to really like, and then the larger print version that homes are hanging up in common areas. I believe you answered that, but if you could just maybe just answer, comment on that, please.
Yeah, so we started working as soon as we had the information and knew what the legislation was and when it was coming into play. We started to work on changing our booklet, but it does have to be changed and it is a bit of a process. So we are going to be putting out the every resident one. You'll still be able to get the old one, but it's going to have shortly, there will be a version where there'll be an insert that will tell you what the changes are. And then the ones that you put up in the home, the big ones, those used to be provided by the ministry. And my understanding is that the ministry actually hasn't answered the question as to whether or not they're going to be provided. So my understanding is that the expectation at the moment is that the home is to do it themselves.
Thank you. That's our understanding as well here at OARC. And just the very last question, this one's coming in from one of our resident leaders, and it's about the Resident Bill of Rights. Is it subject to being suspended by public health? And where is the accountability there? Right.
So again, it can be, I wouldn't say it can be overridden. Yes, it can be. The Health Protection Promotion Act does allow them to do orders that are pretty widespread. Our complaint throughout the pandemic is that they've done directives which direct the home to do certain things, but it doesn't override the residents' rights. But in effect, they have, but we don't think legally. So if the public health makes orders, and you have to understand orders, the good thing about an order is that they have to set out the criteria, their reasoning, and it's appealable. So if for example, they said that no one can have visitors, it's appealable. You can go to the Health Service Appeal Review Board, you can appeal those decisions. And the problem with what's happened is that they put in these, rules in these directives that were not answerable to anyone, and that was really problematic. And so, yes, they can be overridden. They didn't do it properly, in our opinion. If they did it properly, yes, it can be done, but it is appealable. It is much more difficult to deal with the directives when they're overriding rights, when they're not an order, because it's a different kind of court application. And it made it much more difficult, especially with the closure of courts.
Okay, thank you. And there were some questions that we weren't able to get to. It's just after 3:06 now. We will be ending the webinar for today. I wanted to thank Jane again so much for guiding us through the changes with this informative and very in-depth presentation. And to our participants, we really appreciate the time that you've spent with us today. And remind everyone again that the recording and slide deck will be made available through distribution and also on the website. And lastly, we are always encouraged and inspired by your feedback. So we invite you to complete the post-webinar evaluation that will help us identify future learning needs and preferences. That's all for today. Thank you so much for participating. Thanks again, Jane, and we'll see you soon.